Before we dive in, pay attention to the judge's tone. He's clearly keeping this tight, short questions, yes or no answers. This usually means the court wants to avoid emotional detours and stick strictly to legal facts. Watch how many times he redirects her. It reveals a lot about how judges manage parents who start giving long explanations.
I will call the mother. Ma'am, can you state your name for the record?
Crystal Giles.
Ma'am, did you hear the state's proposals that I just read into the record?
Yes.
Are those your agreements? Are those also your proposals?
Yeah, she went back and told me that it was
Ma'am,
eight
ma'am,
eight
ma'am. It's going to be
uh
very important for you to just answer yes or no. Okay, you'll have an
okay.
opportunity.
Yeah.
Okay. And ma'am, you understand that we came up to these amounts based on information received by the employer for the father. You understand that?
Yes.
And who does the child live with?
Me.
Who should the child live with in the future?
Me.
Do you want joint or sole managing conservatorship?
So
Is there an active protective order between you and the father?
no.
Is there an open criminal case?
No.
Is there an open CPS case?
No.
Has there been instances of family violence within the last 2 years?
No.
What is the reason that you want sole managing conservatorship instead of joint?
Okay, pause. This is where things get interesting. The mother is asked if she wants joint or sole conservatorship, but she hesitates. Why is that important? Because conservatorship in Texas isn't just who the child lives with, it's about decision-making power. If you were the judge, would her hesitation make you question her reasoning? Let me know in the comments.
You want me to explain? I don't know if I should say
Yes.
okay. Okay. The reason being is just that she has not been around him as often on a consistent basis, and even with as far as overnight visits, they have not been on a consistent basis. The last time probably was almost like a year and a half ago. So that's why I had requested warm up just to give her a time to readjust to this new schedule and routine, and then possibly talk about her spending the night. Of course, I would need to know she has a bed, where she is, and things like that.
And ma'am, thank you for telling me about visitation. But my question is about conservatorship. It's about decision making. So let me ask you a few more questions about that. We'll circle back to visitation. Who makes the
Me,
day-to-day decisions over the child's life?
me,
Okay. And ma'am, when was the last time that the father saw the child?
mm, may have been May 2024, or even earlier than that.
And is it true that you want a drop-off location, pickup drop-off at Tom Thumb on Skillman Street in Dallas?
Yes,
Okay, and you already mentioned the warm-up visits, correct?
yes,
From 2 to 4 on Saturdays, is that true?
yes.
Every Saturday or just the second and fourth or the first and third?
The second and fourth,
For how many visits?
7 visits is what I was told.
How, how old is the child?
She's 7.
Quick legal insight: retroactive child support isn't just paying back late. The court calculates it based on historical income, time not supported, and any previous contributions. Notice how the mother calmly confirms the $27,012 amount. That tells us she either had legal guidance or came prepared. Meanwhile, watch how the father responds later, very different energy.
Ma'am, are you requesting retroactive support?
Yes.
Um, have you and the father ever lived together during the past 4 years?
No.
Is it true that you want a retroactive support judgment um, of $27,012
Yes.
to be paid out at $275 per month?
Yes.
Do you understand that that's with a credit for past support?
Yes.
Ma'am, do you live in Dallas County?
Yes.
Are you in agreement to stay in Dallas County and surrounding counties until the child is 18?
Yes.
Okay, is there anything else you would like to add?
No.
I pass this witness. I call the father. Sir, can you state your name for the record?
Michael Jones.
And sir, is it true that there has been no family violence within the last 2 years?
Correct.
And sir, you're asking for joint conservatorship. Is that true?
Yes, ma'am.
And sir, is it true that you work at Cisco USA?
Yes, ma'am.
Did you hear the proposed amounts for child support and medical support?
I did.
Do you agree with those?
I do not.
Okay, and why is that, sir?
Because I'm not sure what numbers you guys got, but I do not get paid as much as those numbers are coming out. And truthfully,
Okay,
it'll put me in a position where I wouldn't even be able to survive.
okay. Sir, did you work for this company in since 2024?
Yes.
Okay. Is your company in Texas?
Yes, ma'am.
And you understand that your employer reports your wages to the state of Texas?
Correct.
Your Honor, may I have a brief second to unplug my Alexa?
Okay.
Alexa break, eyes real talk. When someone stops mid-hearing to unplug a device, that usually means they're not used to courtroom formality. Little moments like this tell you a lot about a witness's comfort level. Do you think this helps or hurts his credibility?
Thank you, Your Honor. I had not called her as a witness. I will now proceed with the questioning. Um, Mr. Jones, would it surprise you that your employer reported your wages at $29,229 for the third quarter of this year?
Honestly, I don't know. I do know.
Okay.
Well, go ahead, sorry.
No, go ahead, sir.
What I was gonna say is like the way our incentive system is worked up is a certain amount that I could make, but I'm in a situations where I don't run that high, so I know my number. Like I know my money's not where it used to be.
And sir, you understand you were given credit for 3 other children
Yes, ma'am.
and that your wages were calculated for a full year as stated in the Texas Family Code. You understand that, right?
I do not. I don't even understand Texas code.
Okay, I will move on. Sir, did you hear the amount that the mother is requesting for retroactive judgment?
Yes, I did.
Okay, in the last 4 years, have you provided support to the mother financially?
The past 2 years, no. Previous, I'm sure I have. How much, I don't have a clue.
Well, sir, can you give us an estimate?
It was whatever I had in the moment. Like I don't have a number. I couldn't make up a number. I don't.
And you understand you were given credit for $1,500 at least towards retroactive support. Do you understand that?
Yes, man.
Okay, what do you think the visitation should be?
The schedule that I have, I'm off Tuesdays and Saturdays, and understanding that she goes to school through the week, I'd like to enjoy my time with her Saturdays. Honestly, this Saturday coming up will be lovely if that's okay to put in there.
Okay, and do you just want regular visits or shortened visits like the mother requested?
I prefer regular visits.
Okay, sir. This is your opportunity to tell the judge any information you think is relevant. Go ahead.
So, this whole situation only occurring when the mother found out I had another child. She took her away. Like it wasn't by choice. I tried to reach out in every way possible through her mother. Had my mother contact her mother. Had her godmother. She blocked me on all medias, anything, any access to her. I could not reach her. So it wasn't by choice that we're in this situation. It was by her doing. I'm not one of those people that don't want to be there for their children. I know what it feels like to not have a father. I know who I am and how much my kids drive me, how they push me, how they make me a better person. So being active in their lives is very important to me. Very.
This is the emotional peak of the hearing. The father's speech about being blocked and trying to reach his daughter is raw and heartfelt, but remember, courts care about action, not emotion. Even if everything he says is true, the judge is focused on one big question: have you been consistently visiting or supporting the child? And his own statements show long gaps. That contrast is huge.
I understand the scenario. I understand it's ugly, but I'm looking at the positive side of seeing my daughter again, honestly. And truthfully, like I'm about to be in a hole of whatever amount y'all throw at me. Not to put it that way, but I'm gonna see my daughter. I'm gonna like that. That's all I can take from it.
Thank you, sir. I pass this witness.
Okay. Just a couple things I want to go through before I do a ruling. Is it true, Mr. Jones, you haven't visited in over a year?
Yes, sir. That is true. I couldn't find her. I didn't know where she was. I was trying to contact
I
her.
didn't ask all that. I just asked if you haven't visited in a year.
Yes,
Okay.
sir.
Ms. Cordell, what is the monthly gross? I don't think we mentioned that here in the hearing so that Mr. Jones understands what the number was.
Yeah, just 1 second, Your Honor, if you can bear with me. Pull that up for you. $7,707.59 gross.
Okay, so the state has averaged out your income to about almost 8,000. It's like $7,700 gross pay. And that's what it's the starting number, and then they try to estimate what you would pay in taxes, Social Security, and Medicare, and then they also take out a reduction for you having other children that are not part of this case, and that's how they got to this number. So, do you understand a little better that that's the number that they use for to start as far as what your income is, Mr. Jones?
I do understand, sir, but it doesn't matter. Like, yes, I understand what you're saying.
Okay. I understand maybe you may work with bonuses, commissions, or tips in addition to your regular income. You might even have overtime. But we have to include all those things as your income because it is your income. So if there's some parts of the year where you work more hours or things like that, or you might get bonus at the end of the year, we have to include those. We try to average them out over the year because that way if that somebody gets a let's say somebody gets a bonus in December, if I look at their January check, it would be much different than their December check. So if I looked at the two different checks, one would probably be too low and one would be too high. So we try to average it out over the year. Now we don't know what you're going to earn next year, 12 months from today, but we can usually kind of uh, understand that it'll probably be about the same as you made this year, hopefully more. But that's kind of how we got to these numbers. So you understand that a little better, Mr. Jones?
I do. I have a question.
Yes, sir.
So is there a time where you guys look at those numbers again, or would I have to come back to court to have that looked at like the next quarter or so?
Yeah, I mean, it's not automatically looked at. So we're probably going to have this order for the next 3 years or longer, depending on what happens. I mean, I can't guarantee that, but no one monitors your income. We're doing a final order today, and that's going to be the final order. It could be the only order you ever do, or it could be just one of many orders that you may do. It's just kind of dependent. So, um, so no, it's not going to be, we need to set it at a fixed amount. We cannot vary it based on different months that you might have different income, like have it go up and down. We can't do that. We have to have a fixed amount. And so that's what we average it out over the year. You understand that?
Yes, I understand.
Okay. Do you have health insurance available to you for this child, Mr. Jones?
I do not. Open enrollment just closed.
Okay. Do you know how much it would cost if you enrolled the child on your insurance?
No, sir, I do not.
Okay. Well, I could do an order to have you have the child on your insurance, but I don't want to do that if you don't know how much it costs because it could be worse than the 173. So that may be something you may need to look at it for in the future to save yourself some money. If we do a court order, I don't have to wait till enrollment, but once we're done today, I'm not going to go back and be able to change it. So this will be the order, and then I can't do a new order until something new is filed in court. All right, so let me go ahead and make a ruling then. If they've calculated your numbers on average, then your child support is supposed to be 879 based on your income. Medical support set at 173 since neither one of you are carrying the child on your insurance. I'm gonna appoint the mother as a sole managing conservator. I'm making a finding there's been no family violence. We're gonna do the exchange location for the exchanges for visitation. For visitation, I'm gonna do the second and fourth Saturdays from 2 to 4, but I'm only doing that for 4 visits. So we have a 7-year-old child. It shouldn't take that long for the child to adjust to visiting with Mr. Jones. So whatever issues you had before, maybe with each other, I don't really care about those things. We're here about whether the child's right to visit. So even if y'all don't like each other or whatever, that really isn't relevant or important to the child.
And here comes the judge's final swing, 4 warm-up visits then straight into full standard visitation. This is the court's way of saying we're not dragging this out. Despite the parent's complicated past, the judge centers the child's right to consistent contact. What do you think, fair ruling or too fast? Drop your take.
And so we need to make sure the child visits with dad. Being that dad hasn't been able to visit for whatever reason, I'm not pointing fingers either way, but we're going to do this kind of short phased-in visits for the 4 visits. And after that, it'll be visitation on a standard visitation order. So Mr. Jones will have the right to visit with his daughter from Friday at 6 until Sunday at 6, every other weekend, and also some of the holidays. So that'll be what we do after those 4 visits. So just a short time here, and then we can go into the full visitation. I don't know what you've paid her, Mr. Jones, or if it doesn't sound like it's been very much, especially since communication has been pretty poor. It's what it sounds like to me overall between both of you. So, I mean, not much I can do if you don't tell me anything. If they can only they credit you with 1,500 overall as a total amount for just the 4 years, not the whole life of the child. We're only talking about only the last 4 years. And that comes out to $27,012. I'm gonna lower that payment to 200. And then, but if you can pay more to pay it off, then you can always pay additional. It does accrue interest after a while, so the sooner you can pay it off, the better for you to save yourself some money. I'm kind of give you a little bit of adjustment here since we're kind of putting all these numbers here. Court calls bill to Mr. Jones. All right, the Attorney General's office will draft an order based on that. That'll be the ruling of the court that you must follow, even if you don't agree. All payments must be paid through the child support office. They'll send out a withholding order to take it out of your check soon, beginning in December. All right, y'all are done with court. You can press leave on the Zoom to exit out. Thank you.